Fourth Department. Hear ye, hear ye, hear ye. All persons having business to do before this court will draw near, give their attendance, and they shall be heard.
All right, have a seat, everybody. Okay, good morning. Welcome to the Fourth Department. This is the last day of our term, so you're all very special to us. All right, so let's start with case number 736, People versus Romanchik. Let's give Sarando my videos. Good morning, Mr. Serrano.
Good morning, Your Honor. Can you hear me okay?
We can hear you just fine, and my understanding is you're the only one who's going to be arguing this morning.
Yes, Your Honor. And I can't see you, but I'm sure everybody looks good. Your Honor, this is an appeal from a conviction for the crime of attempted criminal possession of a weapon in the second degree. Following a guilty plea, the defendant has completed his probation. In view of the fact that the people are submitting, I think, our issues and our position is adequately and set forth in our brief, and we would also rely on our brief, unless the court has any questions.
I think we're all good. Thank you so much, Mr. Serrano.
Thank you, Your Honor.
Okay. Number 737, People versus McCullough. Morning, Mr. Leisure.
Good morning, Your Honor. I'm with the Monroe County Public Defender on this case for Sam McCullough. The people have conceded our top point that there was no intent to sell in this case. Knowing that it's the court I need to convince and not just the people, I'm here to see if there was any questions on that.
I have one question. I appreciate the concession and that the criminal possession of a controlled substance in the third degree wasn't met with sufficient evidence here. And so it seems that the concession and sort of the stipulation is to have that reduced to CPCS 7th degree. The thing that I'm concerned with is that we also have a conviction of criminal possession of a controlled substance in the 4th degree based on the quantity.
Right.
And it seemed to me that the CPCS 7th is an inclusory concurrent count of the 4th, so that we shouldn't be reducing it to CPCS in the 7th degree. We should be dismissing it altogether because
that's what we asked for, and I think that's correct, Your Honor.
Okay, all right. So that's the position that you have as well at this point. I wasn't sure from your brief if that's what you were arguing or if you wanted it to be reduced and not dismissed altogether.
No. It should be dismissed. There should only be the 4th degree now.
Okay.
Okay. Very good.
If Your Honor would allow me to just say a few words about the sentence. Mr. McCullough was 48 years old. He was gainfully employed at certain points. He went to two years of community college. His criminal history, although it's certainly there, was all drug related. He has mental illness history. Probation said a probationary sentence would be appropriate. The people asked for 5 years on the top count. This court has reduced 4th degree towards the minimum of 2 years. We think that 2 or 3 years is the appropriate sentence, and the 4th degree sentence ought to be reduced.
Okay, we'll take that under advisement and consider it.
Thank you, Your Honor.
Thank you. People versus Derby. Morning.
Good morning, Your Honors. May it please the court. My plan is to touch upon point 1 and then move to weight of the evidence unless this court has any other questions. With regard to the prosecutor's comment on Mr. Derby's silence, It's true that the jury didn't see the part of the video where Mr. Derby invoked his rights, but it should be noted that the prosecutor elicited from Detective Marola that Mr. Derby only spoke with him for 10 minutes total, that the interview only lasted for 10 minutes. And the jury saw just about 10 minutes of the video. So it would have been evident to them that at that point, right after it cut off, Mr. Derby chose to stop speaking to the police. Conversely, Marola testified that he spoke to Stanley Sawyer at length on the same day, and that he believed Mr. Sawyer to be truthful. And so the context of the prosecutor's statement was that he was talking about Stanley Sawyer's credibility, and he said, Stanley's just filling in some holes because Mr. Derby spoke to the police and did not deny involvement in the crime. So this was suggesting that Mr. Derby's failure to continue speaking to the police was evidence of his guilt and was improper. We understand this is an isolated comment. This wasn't a pervasive pattern. I do think that this is egregious and prejudicial enough to require reversal, but to the extent that the court doesn't think this alone requires reversal, we would at least ask that it look very closely at the jury's credibility determination for the weight of the evidence, because this is something that prejudiced the jury.
Is it possible that the defense attorney, when that comment was made in the opening statement, might have hesitated a moment, because the record, when I went back and looked at the video of the interview, it looked to me that twice the defendant denied. At one point he said, what do you know about that? And he said nothing. He described the incident. And then later in the second video from the flash drive that we received, he said, I'm just trying to tell you, mister, like, I don't got anything to do with it. He didn't say anything. He used a different word, but you know the part I'm talking about.
Yes.
So twice he did. So if you're the defense attorney and you're sitting there and they say he didn't deny it, and you're thinking he did deny it twice, do you object? Do you bring it up in your opening? Do you wait until the proof? Do you address it in closing? You have a bunch of options. And in that split second, you have to object. Is that the way you viewed it too? Or do you think the objection should have been a little bit more of a knee jerk?
I do think that the objection should have been knee jerk, because I think there is just a bright line rule that you don't comment upon a defendant's silence or try to use it as evidence of guilt. And just the defense counsel didn't actually then address this later, as far as I can recall. I don't think defense counsel addressed it in his opening or his closing. So I don't think that could have been his strategy. I do take the court's point that Mr. Derby did deny on the video, but I guess I would just point out that that was really just in the very, very beginning of when he was being accused of this. And he just immediately denied all. He said he didn't even know Stanley Sawyer. He just denied all involvement whatsoever. So he didn't go on to explain to the police, yes, I was walking around with Stanley Sawyer, but I didn't have anything to do with his robberies. I didn't, he was acting on his own when he committed the robbery. So I still think, even though he did make those denials, I still think that this was a harmful comment. And to the extent that the court finds that it doesn't rise to ineffectiveness, we would ask for interest of justice review.
I have one question. Did the court's charge at the end of the trial in any way make up for those comments that may have tended to shift the burden?
I don't think so. Certainly the court's charge is always helpful, but there's a reason that the prosecutor is not allowed to make these types of comments. They have an impact on the jury, and I think sometimes there's a bell you can't unring, and the charge just can't make up for the fact that the stage was set from the very beginning for them to believe that because Mr. Derby didn't continue to speak, because he invoked his right to silence, that had some impact on his guilt.
But that wasn't the comment was that he didn't deny, which maybe even makes it worse because he did deny. So you've got a statement by the prosecutor in an area where he maybe shouldn't have gone, but it's not even true.
Correct.
So,
but
it does leave us with this issue of whether or not your client otherwise got a fair trial, right? Because there was no objection to that. It's not preserved.
Correct.
And
so
there's quite a bit of evidence here that your client was the gunman, right?
I think there was not. I think this was a very close case. So I think this segues right into weight of the evidence, which is, I just want to point out that because this was first-degree felony murder, there the prosecution had to prove that Mr. Derby was an accomplice to the robbery, he had the intent to kill Mr. Musa, and he indeed did fire the fatal shot against Mr. Musa. And I think there was reasonable doubt about all three of those elements. So in terms of whether he was the gunman and fired the fatal shot, there was no evidence about what caliber bullet went into Mr. Musa. And I would ask the court to look closely at the bullet trajectory here, because it's an odd bullet trajectory. And it doesn't match the DA's story at all. The bullet went into Mr. Musa's upper left back and exited out his bottom right buttocks. So it went through the length of his torso, essentially, if he was on the ground, essentially horizontally, and then exited out the bottom of his buttock. So the prosecutor argued that Mr. Derby ran up, he was right over Mr. Musa, and Mr. Musa had his back turned, and Troy Derby just shot him in the back. That's impossible. That's not possible with this bullet trajectory. The person who shot him had to have his gun over Mr. Musa's head. I think a much better, and what defense counsel argued in summation, is a much better match to this trajectory is Stanley Sawyer, who was underneath Musa on the ground in this struggle, was able to, we know the gun was in his right hand. He was able to get his arm free and reach over Mr. Musa's shoulder. That would account for that bullet trajectory going essentially horizontally through Mr. Musa's body.
And these arguments were made during the trial, before the jury?
Correct. Defense counsel made this argument about the bullet trajectory and advanced that Sawyer shot him during the struggle. The prosecutor didn't attempt to account for the bullet trajectory. He just insisted that Mr. Derby went up behind Mr. Musa and shot him in the back without explaining how that was possible.
Right, and that was the witness, the other store clerk, who watched the scene unfold in front of him and saw the defendant walk up to the fight that was happening, tumbling on the street, and then there's a shot fired by your client, the defendant.
I don't.
And we know both guns went off, right? Because we got 9mm and 40 cal cartridges found at the scene.
Correct. So it does definitely suggest that two different people were firing guns. That witness, I think, tried his very best to say what happened here, and we don't doubt that. But I don't think he could have possibly known which gun went off to fire a bullet into Mr. Musa. I mean, that's not something he could have observed. I think watching the video, if you compare this witness Adele's testimony to even his own actions on the video, there's a lot of inconsistencies, which is completely understandable. This all happened in less than a minute. It was dark. It was chaotic. He was, I'm sure, absolutely terrified. And so he did see a second man come up and maybe, he was shooting, but I don't think he could have possibly known that that was the person who actually fired the bullet that killed Mr. Musa. So I think the scientific evidence of the bullet trajectory is much more reliable here. With regard to the casings, I would just point out that the witness Adele specifically said that the second man who came up fired twice, once toward him, and presumably that's the one that went through the door and into the store, and then a second time, which he assumed went into Mr. Musa. But on the scene, there were two .40 caliber casings and two .40 caliber projectiles found. And there was no evidence that either of those projectiles were the one that killed Mr. Musa. There was certainly no DNA on them or anything like that. There was also a 9mm casing found, and that projectile was never found. If that was the bullet that killed Mr. Musa, it was apparently just lost, but I think that makes more sense. I think these arguments that I've been making also go towards the intent element, because again, the arguments about intent are based on this theory that Mr. Derby went up, stood right over Mr. Musa and shot him right in the back. Even if somehow he was able to shoot him in a way that got this odd bullet trajectory, I think that suggests he wasn't standing right over him and shooting down. And the prosecutor argued that Mr. Derby was essentially shooting in a trail from the porch. So the first two casings were found on the porch. I guess, I don't know why he would have started shooting on the porch, except maybe just to scare them, to break up the fight. And he continued shooting down the street and was essentially shooting someone indiscriminately to just kind of try to break up this fight. Even if we can assume that one of his bullets was the one that shot Mr. Musa, I think that would not evince a specific intent to kill him. Finally, backing up a little bit to whether he was proven that he was the accomplice. This robbery is on video. Sawyer did it by himself. Mr. Derby did not participate in this robbery. Sawyer comes in the store. Mr. Derby was 90 yards away on a porch. The prosecutor repeatedly insisted that Mr. Derby was the lookout, but even Sawyer didn't testify that he was the lookout. Sawyer never said that that was his role in the incident. He was also pretty far away, I would argue, to be an effective lookout. He appeared to just be on a porch waiting for Mr. Sawyer. And even if he knew what Mr. Sawyer was about to go do, that doesn't make him an accomplice if he wasn't participating as well. According to Mr. Sawyer, Mr. Derby gave him the gun and told him to commit this robbery. That would be an accomplice if that were true. But Sawyer was an extraordinarily incredible witness. I mean, he had every motive in the world to blame his robbery entirely on Mr. Derby, to say, you have me dead to rights on camera committing this robbery. You have my DNA in the sweatshirt and on the mask. And therefore, I'm going to tell you that this other person that I was with, he was the mastermind. He was the person who actually came and fired the fatal shot. Mr. Sawyer was facing life imprisonment. I mean, there are many, many criminal defendants who have gone to prison for the rest of their lives for what Mr. Sawyer did here or less. And he ultimately ended up getting 12 years in prison. He got an extraordinarily good deal to testify against Mr. Derby and blame this crime entirely on him. And his testimony should be looked at very, very skeptically.
And I promise we will do so.
Okay, thank you.
Thank you, counsel.
Morning, Your Honors. David Bassett for the people. This comment in the opening, we would submit, did not unfairly prejudice the defendant. A single comment which referenced what he said on the video, which the jury was going to see anyway, under these circumstances, did not unfairly prejudice the defendant.
You're not arguing that it was proper. I mean, you sort of acknowledge here that it was an improper comment, correct?
Well, we would argue that it was referencing the video that prosecution was going to show, but really they expected the video to show.
Yeah, but I mean, it really couldn't have done that because the defendant did deny that he had anything to do with it. I mean, it was improper and maybe even false. That's not your point, though. Your point is, nevertheless,
right,
it was a fair trial.
We would submit that it doesn't rise to the level of sidetracking the jury, which is the test, to unfairly prejudice defendant and deprive him of a fair trial, especially in light of all of the people's evidence, which gets to defendant's second point. The people's evidence in this case, we would submit, was very strong. You have Sawyer's testimony. He is the man who goes into the market, gets into a struggle with the clerk, Musa, spills outside, and as he's struggling with Musa on the ground, Sawyer testifies the defendant comes over, shoots Musa in the back. The other clerk, Gaithy, is outside. He sees another man also run up and shoot Musa in the back. These are two witnesses. The defendant is essentially asking you to throw their testimony out because of a speculation about bullet trajectories. And we would submit, well, the bullet could have bounced within Musa as they are prone to do.
But we don't have to speculate about that either. The jury heard it and determined what happened.
Right. This is ultimately a credibility determination with respect to these witnesses. And the jury was in the best position to evaluate their credibility in light of all the evidence, which we would submit was consistent with and corroborated those witnesses. You see the videos from the bus where they board together, Sawyer and Derby. Derby acknowledges he was in that bus with Sawyer an hour before the robbery and murder. You have the videos tracking them to the market. You have the video from the market showing Sawyer go in, struggle with Musa, spill out. You've got the video showing defendant leave the porch nearby, running towards the scene of the market. Then you have the struggle, the gunshot, which is testified to by by Gaithy and Sawyer. You have the ballistics on scene, which support their account, which show a 40 caliber casing from the porch, a few of those trailing to the market, a single 40 caliber by Musa's body. You've got a 9mm casing also nearby, and a 9mm magazine, which is consistent with Sawyer's testimony that his gun went off in the struggle and the magazine fell out. And you've got the forensic examiner and the autopsy evidence, which shows that Musa was struck with a single shot in the back, as testified to by the witnesses. We would submit, based on all this evidence, the convictions were consistent with the weight of the evidence. The jury's decision should be left as is. And if there's no further questions, I'll step down. Thank you.
Case number 740, People versus Dyer. Morning, counsel.
Good morning. May it please the court. Braden Gilman for Brian Dyer. The people here failed to disprove that Mr. Dyer was justified when he used physical force to repel the complainant's attack.
Counsel, let me stop you. My reading of the record is that there was, two different, I don't want to say totally different, but two different versions of what happened here, right?
That's correct.
And if you believe one, there might be justification. If you believe the other, there certainly wouldn't be justification.
That's possible, yes.
Okay, so, I guess we have a situation where credibility and what the jury thought of the testimony is pretty critical.
Mm-hmm.
And maybe, in fact, carried the day.
Yeah, and this was a bench trial, but the credibility of the complainant here was not credible. At one point, he was asked.
Wasn't there a cabbie though? There was an independent cabbie, right? Who also gave testimony during the bench trial, correct?
Yes.
And kind of corroborated what the victim's version was more than the defendant's version.
Well, I would offer that her testimony was consistent in part with the Mr. Dyer's testimony. She testified that at the time that he was struck, the complainant was facing Mr. Dyer, and that he grabbed him either by the neck or shoulder. I think by that positioning, that is consistent with what Mr. Dyer stated that he believed, which was that the complainant was choking him. He testified that he felt that he was choking him to the point that he was going to pass out. Throughout that day, prior to this immediate altercation, Mr. Dyer testified that the complainant had been choking him to the point where he had to leave the situation because he had such severe pain on his throat. He left the situation, went next door, came back, and that's when the altercation ensued. That the complainant never talks about any rising action to understand why we got to this place. He never talks about why either party were agitated. The complainant, at one point he's asked whether both of Mr. Dyer and himself had been heavily drinking that day. He says, no, I wasn't. He's asked how much had he had to drink. He said 6 or 7 beers. But just generally, Mr. Dyer did have a reasonable subjective belief because of his previous encounters with the complainant, who he had tried to have evicted from this house because of his kind of bullying behavior. It seems like they had been rough housing, and there's some horseplay, according to Mr. Dyer, throughout the weeks leading up to this incident.
The one thing that struck me, just getting back for a moment as to how it occurred, Mr. Dyer's testimony was that when he had the statue in his hand, his feet were in the air, his arms were flailing, and that essentially the victim was in front of him, and he claimed he was trying to choke him. The victim, I think, said he was trying to steady him because he was sort of falling backward or falling to the side. But then with his feet in the air and his arms flailing, he then struck him with the statue. But the injury to the victim was in the back of his head.
That's correct.
So how does he get the statue around the front and top and back of his head? Or was it reasonable for the court to determine, as the fact finder, to determine, well, that doesn't make sense to me? Was that fair of the court, or should the court have somehow figured out how he could get his arm all the way around to the back of his head?
I believe that was consistent with the testimony of all three individuals. Wells's testimony was that he had been, the complainant was facing Mr. Dyer and was struck on the back of the head. And both parties did testify that he was being held over the railing when he was struck. And I believe that is consistent with the testimonies of all of the principal witnesses here. Just briefly going to the dangerous instrument and the serious physical injury here. This was not a serious physical injury. Officer Camp testified that while this instrument could have caused a serious physical injury, in this case, it did not.
Okay, so I guess what I have from the record is that there was a concussion suffered and 5 staples to his head.
That is correct.
And it's your position that's not a serious injury?
That is correct. The complainant, he was struck, and Mr. Dyer's feet were not on the ground. He struck him with his non-dominant hands. He was heavily intoxicated. The complainant's first reaction was to, according to Mr. Dyer, was to smile at him. He allegedly said, "You effed up."
But tell us how it's not a serious injury instead of explaining all that.
Yeah.
Peripheral stuff.
He did not, he was able to walk to the hospital. The complainant chose to walk to the hospital rather than going. Dr. Lamb, who was the doctor in this case, testified that this injury did not cause substantial risk of death.
Well, he was acquitted of assault first.
That is correct.
Right. This is assault second, 0.05 subdivision 2, which intent to cause a physical injury. It doesn't reference a serious physical injury.
I'm speaking of the criminal possession of the weapon. It's the physical injury with the dangerous instrument portion. And
they're saying it's not a serious physical injury. It's not necessary. He was acquitted of that. So you're saying that it's not an instrument or capable of causing serious physical injury.
Given the circumstances.
Isn't it a concrete figure? I mean, just take a rock. Is a rock?
Yeah, concrete or ceramic.
Is a rock similar? Could that be used to cause physical injury?
It's under the circumstances it's used, as well as with the readily capable. So both elements, we purport that both elements are necessary. For example, there was a case in this court in 1986, People versus Joan Green, and that was 12480 2D 1065. In that case, the person allegedly had spike-heeled shoes and struck an elderly person and caused severe bleeding, severe bruising on the complainant. This court dismissed the criminal possession of a weapon in the 4th degree because it found that there was not evidence of serious physical injury. We offer that this is a similar circumstance and that this case should be dismissed accordingly.
Thank you, counsel.
Thank you.
Good morning, Your Honors. May it please the court, Will Zickel for the people. With respect to the weight of the evidence argument, this is a straight credibility kind of case where the trier of fact, in this case the court, is able to accept certain testimony and reject other testimony. And that is clearly what happened during the process of deliberation. The only evidence I submit that there was any sort of justification that even could be considered by the trier of fact in this case was the testimony of the defendant. The testimony of the disinterested third party, the taxi driver who was there to pick up the victim, was consistent and almost down the line with the testimony of the victim, including, and counsel and I may disagree on this point, and I know the court is very capable of reading the record and determining the testimonies of the witnesses. But that disinterested third party said that the victim was facing away from the defendant when he was struck. There had been something of a struggle apparently on the porch, but the victim turned away at the time that he was struck. And that explains, of course, the injury to the back of his head. It's absolutely consistent with the injury that was found.
Yeah, I mean, reading the witness's testimony, the cab driver, we'll take a closer look at it, but it seemed like there was a beat, there was a moment of difference. Of they were, this sort of struggle. And then I think she said the defendant then smacked him in the back of the head, as if there was, a moment passed. And my reading it, I thought that he had turned, but we'll take a look at it.
Yes, and I think that those events happened in ad seriatim and in very close succession to each other. But again, I think that the struggle or the scuffle on the porch was also precipitated, and this is consistent with the taxi driver's testimony also, that the defendant was slamming the gate or closing the gate on the victim's legs or his knees. And that's what caused the victim to turn around and, I guess, engage with the defendant on the porch. There's the scuffle or the struggle, turns away, and then the impact of the 5-pound ceramic or cement statue. And that's of course, very important in terms of the court's consideration of whether or not that object was capable of producing serious physical injury, not whether it did or not, but whether it was capable. And of course, the manner in which it was used was to strike another person over the head. That's the manner it was used, regardless of whether or not serious physical injury resulted. The repugnancy claim is not preserved first, and it simply doesn't pass the impossibility test or the conceivability test, as I call it. And so that certainly should be rejected by the court.
Thank you, counsel.
Thank you.
Okay, case number 741, Litwinski versus Adenoff. And my understanding, everybody's going to be on the video.
Your Honor, can you hear me?
We can hear you and we can see you.
Oh, good, because I was having some internet issues about 20 minutes ago.
Right now, you're good.
Good. Have the others joined in yet?
Yes, everybody, they're not all in yet, but here we go. Mr. Jerzembek, I see you. Can you hear us? We can't hear you, Mr. Jerzembek. We can't hear you.
It's muted.
Oh, you're muted. How about you unmute yourself so we make sure we got a good connection?
Okay. Can you hear me now?
We can hear you. That's great.
Okay. Yeah, I had the same problem with technology about 15 minutes ago.
Okay, I'm going to take that back. We can hear you, but it's not great. There's a lot of feedback. Okay. All right, Miss Jessie, can you hear us?
I can, Judge. Can you hear me?
We sure can. Okay, let's begin. Mr. Greenberg?
Yes, thank you, Your Honor. My client is objecting, and I'm representing Mr. Lubinski in his objection to the transfer of the relocation from Erie County to Cattaraugus County. Our position is that Ms. Adinolfi did not really present any compelling reasons as to why this move would be in the child's best interest. I mean, she certainly it's understandable that she would want to move to Brockton to be with her new husband, and we would not deny that. But how exactly does the son benefit from all of that? And because I think one of the more interesting reasons that she gave, I mean, well, the reasons she gave were really her convenience. She wanted to be closer to her husband, and she wanted to be closer to the hospital where she works. Well, you know, when you look at Google Maps, I mean, the amount of distance is not particularly insurmountable, whether she to the hospitals where she works. I think I mentioned in my brief it was 20 miles, 23 miles, 19 miles, and 38 miles, and though those are not, you know, it's not like she's working in a hospital in Albany or in Rochester where, you know, where the
Okay,
distance can
so
be.
Mr. Greenberg, we all,
Yes.
many of us live in that area, and there's another factor besides mileage, and that can also be the difficult weather, especially on that route from Hamburg to Brockton.
Yes, there can be difficult weather in the wintertime, and I won't deny that. But the question should always be, how does this benefit the child? I mean, how does the move benefit the child? And that's when you look at Tropea and the other relevant case law, it has to be in the child's best interest. Now, I can understand why it's in her best interest, but you know, when the reasons that she was giving were very vague, and at one point she's referring to stars and trees in her testimony, and that's not. I'm sure that the scenery in down in Brockton may be quite lovely, but that's not really. I mean, it doesn't really show as to how the sun is benefiting from it.
Wasn't there a testimony regarding it being a smaller school district? A little bit more, the child would get more attention from that, smaller classes. I recall reading that was part of the evidence that the mom put on, in addition to obviously being in one household. I know districts forget that, but if they're in one household, they're saving money, right? The
Oh, I
mom,
mean,
husband.
oh, I'm sorry, go on, Your Honor.
I was finished.
I apologize. And no, I think those are two very good points. The school system may be smaller and more personalized, but she didn't really connect it how it's better though. I mean, how is the Brockton school system better than the Hamburg school better for the son? Because that's where she never made that connection. And she also voiced it with her personal opinion. I mean, it's like, well, did she present any hard data? I mean, like, what programs does the Brockton school system have that the son would benefit from? And though those are really really connected directly to the son, and I don't think she did that. And the other question
Well,
was
Mr. Greenberg,
yes.
she also talked about the fact that the child had some, other family nearby down in Brockton, that actually lived in the household, like step siblings, that he would benefit from living in the same household with.
But that argument, Your Honor, could go both ways because he also has, he also has the family in his father's household as well. So I mean that's not really. I mean, I do appreciate the argument, Your Honor, but that can go in both directions because he has friends on both sides. He has friends in Hamburg and family in Hamburg and friends in Brock. I'm sure at this point he's been there for about 2 years. Friends in Brockton and certainly has the family in Brockton. But
Mr. Greenberg,
yes.
I'd like to just say that I think we would all agree that the father and the son had a very close relationship that, jumped out on the pages that they were close. Okay.
Yes, they are.
So we can't deny that. Okay.
But then the question is that did ultimately, Your Honor, I think that the question ultimately is did family court correctly apply the Tropea factors in this case? And our position is that it did not. I mean, there is closeness on both sides and family on both sides, but how did the child's life be enhanced by the move to Brockton or Brockton? Yes, thank you. If there are any other questions?
Just one last question, just with respect to most relocation cases we see, there's a built-in assumption, or sometimes it's very clearly stated that the party that is not relocating, they're going to lose significant access time, visitation time, because their child is leaving and they're going some distance away. This case is a little bit unique and a little bit different, where the mother is able to account for basically allow the father to have the same time that he had before, adjust the schedule, no doubt, but to have make up time, that additional weekend and more time over the summer, that sort of thing. Do you think that should come into play when you're doing a tropea analysis in the rare case where actually the person isn't losing all that much time?
Well, I think that's a very good point, Your Honor. I'm glad that you made it, but in reality, in the intervening 2 years, he actually has lost time because he's not a wealthy person, and he related to me when we reviewed the case yesterday. Is that, well, he may have all this additional time on paper, getting to the point where he can actually exercise the visitation is imposing a financial burden on him. So that's why, it's not enough to simply look at the bare bones schedule, but you have to say, we'll also have to look at the ability of the visiting parent to to implement the schedule with the resources that he or her would have. So, I mean, that's something which I think the court should take into consideration.
Mr. Greenberg, this is a 2022 order.
Right.
I'm curious, has your client seen the child? I mean, the mom, I assume, moved.
Right.
And is your client seeing the child Friday through Sunday?
My understanding is that part of the visitation is continuing, yes.
Thank you.
So in essence, they've been working under this agreement from 2022, which is 3 years. There's no stay here, so the agreement has been in effect for these last 3 years. Is that correct?
I think it's in effect, but as I mentioned to Justice Nowak's inquiry, is that the part of the agreement that he's having difficulty implementing is not so much as the weekends, but with going down for the weekday portion of it can be quite financially taxing on him. So that part of it is an issue.
Is he still coaching the son? Is he still involved with that? I know he was involved with coaching the son. Is he still involved with that? And apparently he had the opportunity in Brockton as well.
I believe, my understanding is that he's still involved with the son's life. I mean, I can't answer a specific question about coaching. I do know that he is still involved as a general principle, he's still involved with his son's life. I can certainly inquire and then submit something post-argument if you want me to find out the answer to that specific question about the coaching, if it would be helpful.
It appears you're making a financial argument, but my understanding at the time of this hearing, your client wasn't even paying child support at the time.
I'm not certain that one way or the other. I don't think that was reflected in the record.
Oh, it was reflected in the record, but I mean, I don't know if anything's changed.
That I don't know.
Okay.
And you're claiming it's the distance, I think 20 miles, like you said, maybe a little bit more. Is that the financial expense that you're indicating that it's additional 20 miles between I have to make now to get to Brockton?
Well, I think that's part of it, but I think that the more important reason is that he doesn't really understand as to why the court allowed the relocation to proceed on such very generic things like, the better landscaping in Brockton or trees and allowing, less noise, less pollution and very without any kind of substantive, like if you want to say that the schools are better in Brockton, does she have any evidence for that? And I think that's the part of it that he was having trouble understanding. It's not just simply the expense of implementing the visitation schedule, but I think his primary argument is that the relocation shouldn't have gone forward on such what he considers to be very, very generic reasons.
Yes, and I guess we can hear from the AFC too, as far as how the child is doing as far as in school and education and other factors.
Sure.
Thank you.
Well,
Thank you.
I think she would be closer to it than I would be.
Thank you, Mr. Greenberg.
You're welcome.
Mr. Jarzenbach?
Good morning. May it please the court, Joseph Jarzembek for mom, Jennifer Adinolfi. Respectfully, it's our position that the trial court's decision should be deferred to. They had the opportunity to listen to both of the witnesses in the case. I would note that, as the court is aware, there was a prior order a year before where during the middle of a hearing, the father left the courtroom. And then that order became a de facto default order. My client's been very amenable to providing extensive access to the father. And as the court has indicated, one of the reasons why my client wanted to move to Brockton was because it was a smaller school district, and within that smaller school district, the child Camden could actually receive more and better services in a smaller school setting. I would note, as has been mentioned already, prior to at least this hearing, which admittedly was almost 2 years ago, the father was not even paying any child support for a long period of time. So it's not indicative of someone that was he was involved with the child. And my she clearly testified that she wanted the father to have a connection with the child, and she was more than willing. And the court order gave him a lot of access, as the courts indicated, multiple weekends a month, plus some visitation during the week. I believe that it's in the best interest of the child that my client be awarded custody, and ask respectfully that this court would affirm the trial court decision. And I'm open to any other questions that the court may have. Otherwise, I'll rest on my brief.
Okay, thank you, Mr. Jarzenberg.
Thank you very much.
Ms. Jessica?
Yes, Judge. The lower court applied the correct legal standard. Not every move triggers the tropea factors, and there wasn't even any testimony regarding the additional mileage here, but I think we all know where Brockton is compared to Hamburg. Mom has always been agreeable to allowing access with Camden. She testified that she didn't bring an action to get child support because she didn't want a frustrated relationship with the father. She wanted him to be in Camden's life, and he is. It's my understanding Dad exercises all of his weekend access. It's the Wednesday that he's allowed that sometimes he does not, because it is a little bit of a drive, but he gets 3 weekends a month. Camden enjoys it, and it's my understanding, Dad has continued to enjoy it as well. I'm seeking an affirmance.
How's the child doing?
Yeah.
He's doing well. He's in the Brockton School District. He's 11 now. And he's adjusted well. And the reality is, Mom had sole custody, and mom got married. That's what happened. And she's lucky enough that she has a very good income. She's a respiratory therapist. She was able to get a job at a hospital in Brockton. So I think Camden benefits from all of that.
Okay, very good. Thank you, Counsel.
Thank you.
Judge.
Okay, case number 742. Counsel? Wayne County versus Sarah and Ryan V, right? No. Okay. 742. Matter of Kevin V.
We're looking for the Susan Gray.
Yeah, Susan Gray. Just one person is set to appear.
Ended. There we go.
Okay, Ms. Gray, can you hear us?
I can, Your Honor. I can't see you, but I can hear you.
Okay, well, we can see you and we can hear you, and you're the only person arguing.
That's what I assume, Judge. Thank you. I represent Kevin, who's now 3.5 years old, and I can report to the court that he's doing very well in his foster home placement. It's a pre-adoptive home. He's receiving therapies on a weekly basis. Very active young man, and doing very well. As far as the request made by the appellant father, it's hard to imagine that this type of trauma that was intentionally inflicted on a 5-month-old would not be considered severe abuse by any rational person. Both appellants were represented by counsel, and they were well aware of the potential consequences of a finding against them. I think it is true that perhaps the notice and evidentiary protocols might not have been strictly followed by the lower court, but the case law supports the lower court's actions and decisions as noted in my brief. So on behalf of Kevin, it's my belief that's in his best interest that the parental rights be terminated and he be freed for adoption.
Okay, it's probably harder to ask you these questions about the procedure and whether all the parents' rights were respected by jumping ahead and not doing a hearing. But we have that brief. If there's anything else you want to say about that, we do have some concerns about that.
I understand that, Your Honor, but I do think that the testimony was so compelling the first time around that the court could take judicial notice of it and say that nothing does constitute severe abuse.
Yeah, Ms. Gray, you made that point in your brief too. I saw on pages 8 and 9 that you indicated that the evidence from the Article 10 proceeding was summarized, the medical records and testimony, and the court took judicial notice of same, and it became part of the record in the instant appeal. In the record we have, I don't have anything from the Article 10. All I have is a 13-page bench decision from January 12th, 2023. You're not we're not looking at the wrong record or something, are we? All we have is a decision here, right?
Correct. That's correct, Your Honor.
Okay.
Okay, we'll take a good look at that, but thank you.
Okay, thank you.
Okay, case number 743 through 746, matter of MyLT. This is the Erie County Department of Social Services.
Good morning, Your Honors.
Good morning. Okay, Ms. Lorenz, I think it's your floor. And we have
Thank
Mr. Muldoon is here, okay?
Okay. Good morning. May it please the court. Jennifer Lorenz, attorney for the child, Mile. Just briefly, as indicated in my brief, I believe there's ample evidence in the record to support the neglect finding against the mother. And I guess unless the court has any questions, I will rest on my brief.
We have read the record. We have read the record. Okay.
I'm sure you have.
Yeah, we'll let you rest on your brief. Mr. Muldoon?
May it please the court, Gary Muldoon for the child Tracy, who was 13 years old. I take a different position on the finding of neglect as to my client. My client is in a quite different kind of situation, both below and on appeal. The AFCs for this child have argued that the department's neglect evidence was insufficient. Yes, there were problems with electricity, and this is going back to the year 2020, just before the pandemic. But there's no proof, direct or derivative, that my client was affected. This child was not at the house. There was problems with the electricity, but he was not at the house when the department visited. As a matter of fact, his
Can I just ask you this? So your client is, how old did you say?
13 years
Okay.
old now.
And I'm just gonna ask you, are you making this argument for her? Or are you substituting judgment? I just want to know where these arguments are.
I'm not substituting judgment in this matter.
Okay, so this is what she wants.
For the boy, yes. Boy's name is Tracy.
Okay.
Do me a favor, Mr. Muldoon. We're not supposed to give the names of the children. So it happened more than once already. And I'm like, oh, I got to say something then.
And I thank the court for pointing that out. Yes.
Yes, thank you.
The child was with the mother at the time that the Department of Social Services visited. He was having a psych evaluation. He was having a bit of a breakdown. And so the department arrives at the apartment, a low-income unit, I believe, and the electricity is out. Now there's this.
Was he living there?
Yes.
Ordinarily? Okay, but
Yeah.
when the department came by, he wasn't there, he was with his mother getting evaluation, but.
Yes.
But still, he was living there predominantly when he wasn't getting this psych evaluation, correct?
Yes, Your Honor.
Okay, and then, so there was no electricity.
There was electricity.
Limited electricity, I'm sorry.
There was an extension cord. The electricity was out for 3 days and then it got back on again. But the electricity was on, it was normal temperature as appears. so that there was a bad way of solving a problem, but it was a temporary solution.
Counselor, the lack of electricity or the electricity deficiency wasn't the real issue in the case. It was mother's chronic drug abuse as it related to all of the children.
No, I don't believe there was any, I didn't see it that way at all. There's a dearth of testimony as to the mother, a dearth of testimony as to her, and the concern that was with her was that it appeared that they were criticizing her for having making a poor decision regarding who the babysitter should be. When the babysitters, when the Department of Social Services arrived, the babysitters were sleeping.
No, they weren't sleeping. They couldn't even wake them up.
Okay, correct.
Right.
My client, the child, was not present during that. So I don't see chronic drug abuse as being an issue in this case.
I'm reading in the record somewhere where the counselor said that during her testimony that mother was spending $100 a week on drugs. You know,
What's the basis of that? I'm
okay, so you think that that's wrong? That's not a proper recitation of what the facts might have been in the record?
correct, Your Honor. So my belief, my position, and I'm not substituting judgment for this child, is that and I would note that under Michael B., the child is living with the mother and siblings in Buffalo, and I visited him at the house, and things seem to be going well.
Okay, so you're asking us to look at this very carefully.
Yes, and I should note that there were 4 AFCs in this case, and 3 of them were in favor of dismissal, as I recall, and 1 took a different position.
Right, and that would be you, or the person that.
No. 3 were in favor of dismissal, as I understand it, and 1, as Ms. Lawrence has indicated, is taking a different position.
Okay. Thank you, Mr. Muldoon.
Thank you.
Okay, case number 747, Laura LM versus Trina LC. Okay, Ms. Connolly has submitted, and Ms. Kathy will appear by video. Hello, can you hear us, Ms. Kathy?
Yes, I can. Thank you.
Very good. Okay, we can hear you and see you. You're the only person arguing this morning.
Yes, good morning. May it please the court. Donna Cathy here for the child, as the attorney for the child. I'm here to ask the court to affirm the lower court trial judgment in relationship to this matter and find that family offenses were supported by the evidence and resulted in the correct issuance of an order of protection by the lower court. That would be as the court is aware, do not harass, annoy, or alarm order of protection. I do need to note that in the record on page 2, there is an error in the date of birth. It says 2009 and actually it's 2008. I'm basically here to give the court an update on my client as well as answer any questions. Other than that, I do stand on the papers. I do ask the court to find that the family offense of harassment in the 2nd degree under subdivision 1 for physical contact, as well as subdivision 3 for continuing act of conduct, do apply and are supported by the record in this case. My client is 17 years old. She's in 12th grade. She is employed, working right now. She's doing very well. As the court is aware, based upon the record, she left the family home in October, the home with her mother in October of 2023. She's been with her brother since that time. Only recently has she, other than at court proceedings, just visually seen her mother, and she's only recently had some contact by electronic means, kind of sporadically, and saw her mother at a family reunion for a short period of time. The order of protection, as the court's aware, expired on September 6th this year. So that's not in effect at this time, but we're asking that the court affirm the finding of the lower court that family offenses did occur and uphold the judgment. Thank you.
Okay, thank you, Wendy. Case number 748, Gross versus Building Solutions, Inc. And for the record, Justice Kane is recused from this matter.
Good morning.
Morning.
May it please the court.
Hold on one second.
Joshua Lippers representing plaintiffs' appellates. There are three central arguments contained within my brief, which I would like to briefly discuss. First, the trial court erred by refusing to apply the continuous wrong doctrine to the ongoing discharges from the 36-inch culvert pipe. The trial court...
Counsel, isn't that because what I read in the record was that those particular problems with the 36-inch culvert had been remedied and there were certificates of compliance from the DEC, so therefore it's a claim that there isn't continuous damage.
No, Your Honor. The pipe continues to discharge water, mud, debris, other hazardous materials onto my client's property. The reason the court stated that the continuous wrong doctrine didn't apply was because defense counsel cited a case that said that all of the wrongs were cited back to one specific act, the installation of the culvert pipe. I don't want to make my opposing counsel's argument, but that was the position the court took. We believe that the court erred in taking that position for a number of reasons. For one, the cases cited by the defendant are distinguishable. All those cases where there was one specific act, the damages were fixed at the time the act was taken. Here, the damages changed. There was different levels of water, different levels of debris and mud that come through this culvert pipe on a daily basis. For example, one of the cases, the Solomon case the defense cited, was a case where a person started having 15% of her paycheck removed for health insurance. 4 or 5 years later, she brings a lawsuit and says, this is a continuous wrong because that amount keeps coming out of my check. But the court said you should have known that the moment you received the check. So one of the main issues is when the damages became apparent. The court thinks that because of these notices of violation and consent orders, that the damages became apparent at the time those were issued, but those were issued to the defense. They weren't issued to my clients. There's no evidence in the record that shows when these damages became apparent to the plaintiffs.
So if there was a viable continuous tort claim, okay, then then it would be wrong because the statute of limitations didn't expire. Is that what you're saying?
Correct.
Okay.
Right.
So-
And it should go back from 3 years from the moment they filed their lawsuit. Any damages before that would be beyond the statute of limitations. The second main argument of my brief.
Before you abandon the first argument, I don't mean abandon, I mean move on to the next one. What I would expect to happen, I mean, if you have a situation where you have this culvert pipe and there's a notice of violation, DEC is involved investigating it, and we had the removal and disposal of the debris. This is back in 2016. If at some point something changes, either the material that's coming out of the pipe is either different or greater in volume. What I would expect would happen would be another call to the DEC. Somebody, perhaps your clients, would contact the DEC and say, we have a change here. This is now different. Somebody's disposing of something, something's happening that's unique. Then they'd come back out and then we'd have a new situation. It seems to me you're arguing that all of that happened, but we just didn't get the call to the DEC.
Well, I'm arguing that my clients didn't necessarily know that any of the consent orders or notices of violations occurred at the time they occurred.
What happened with the DEC is not important in this case, you're saying?
It's important the fact that it shows a pattern of disregard for my client's property rights, and that is why they were included in the initial complaint, to show that this is what was occurring, and then my clients became aware of it, and it continued to occur. And they did make calls to the DEC. I don't know exactly what happened out of it, but there were calls about And DC officers did come out to the property and see things that happened, including debris and other things that my clients alleged were thrown, not necessarily from the culvert pipe, but thrown onto their property or dropped onto their property or migrated onto their property, but not from the culvert pipe.
But the claim here is from the culvert pipe.
Well, there are multiple claims. My clients not only claim about the culvert pipe was what the court used to say this wasn't a continuous wrong, that all the damages that my clients incurred were directed back to that culvert pipe. The second argument I brief is that's not the case. That there were other wrongs that happened that had nothing to do with that culvert pipe, and the court was improper to loop them all together into that one mechanism of discharge. And not
your point is there was one act is installing the pipe, but there are other tortious acts.
Correct. One act.
But if there are other independent tortious acts, that's not necessarily relying on the continuous tort doctrine, though.
Correct, Judge.
That's a different theory here.
Yes, correct.
But as it relates to the pipe, though, the installation of the pipe and the visibility of the pipe, that's the moment as it relates to any discharge from the pipe that the cause of action accrued, correct?
Well, that's the moment that the pipe was installed. Doesn't necessarily mean that they knew that damages were occurring, and then they knew that things were being discharged onto their property. That is not on the record. There's no question of when did you become aware that this substances were being discharged on your property, or when did you become aware that these notice of violation and consent orders had happened. And that would be the moment where the damages became apparent. Or if they had testing, when did the testing happen? And you determined that the damages happened. This goes back to the other two cases cited by the defendant. In the Webster case, they said the sediment happened during the construction, so their damage was apparent at the time of the construction that occurred in the Webster case. In the EPK case, which is the other case cited by the defendant, they had a plan to build on this wetland property, and they had a study done in 2010, and the study said you can't build on this property. So it became apparent when the study was done. So there's nothing in the record similar that they can point to showing this is where the plaintiffs became aware and the damages became apparent, and therefore the continuous wrong doctrine does not apply. Which brings me to my third point of my brief, which is that depositions were never taken. This was premature. Depositions were actually scheduled the day after the summary judgment was submitted. And in order to fully understand damages in the case and represent themselves, depositions should have been taken. And the information that was sought by the plaintiffs from the defendants would have come from the depositions. Depositions had been scheduled a number of times, but for one reason or another, they were rescheduled until finally the day after the summary judgment motion was filed. So those are the three main arguments. And if the court does not have any questions, any further questions, I will rest on my.
I think we understand. Thank you very much.
Thank you.
May it please the court, Frank Jacobson from Ralph Larigo's office here on behalf of the respondents, Mr. Huber and Building Solutions. This is a classic case where it's a switcheroo that happened before the lower court. We had a lawsuit pleading stage. We had a motion for a preliminary injunction. We had discovery, all relating to three items. 1, 2, 3. These are the three things that they've supposedly done. They're discharging onto our property, all barred by the statute of limitations. We bring the motion for summary judgment barred by the statute of limitations. Now the appellants realize that their claims are all barred. They change everything in this case.
Talk to us a little bit about the continuous tort issue.
I think that this court's holding in EPK is exactly on point. When you have an original wrong and just consequential damages, there is no change in the statute of limitations. Keep in mind, we like to say this pipe. This is a culvert, okay? This is a natural stream that flowed from far away from my client's property. It's actually all going into Cazenovia Creek eventually. I'm sure many of your honors are in this area and know the area well, but it goes across, it's actually a stream that went from far away, goes across my client's property and then onto their property and then into Cazenovia Creek. The natural flow of it is just diverted into a culvert, predating my client's ownership of it altogether. There was already a culvert there that directed the flow across the property, the natural stream. My client's only conduct was to extend that a little further. The pipe just extended further, still discharging onto their own property, important to note, but it's the natural flow of the stream. Nuisance requires us to actually discharge. Nothing is discharged from my clients into this stream. It's coming from upstream, flowing downstream across their property. We really don't discharge anything. As a matter of fact, our clients, when they purchase the property, again, the culvert actually predates my client owning the property. Purchase the property is going to improve the property, make it better. And extends the culvert so the more the property is usable. But it's still,
sorry to interrupt, but if something occurred upstream, a different, something else is now going into the water stream and into the source. And I appreciate there's more than just water there, but something's going into so that whatever's coming out of the culvert now as extended is different and is now getting onto the plaintiff's property. What the first step would be is to contact the DEC, have them investigate and try to find the source of it. And then perhaps you would argue the claim is against whoever is the source of that contamination, not necessarily your client where all you did is extend a pipe further.
correct. And then we still get to the water. This is a specific water flow case. And we have our water flow engineer who's looked at this and provides all the facts and everything. Our clients actually have decreased the flow of water, which was demonstrated in their undisputed report, where they put in a water system to trap the water and keep it on their land. They extended the culvert, which again, it continues the natural flow. But then you have to go to the surface water doctrine, I'll call it the surface water doctrine, which is if they're claiming that it is surface water, which apparently is what they are claiming, then they have to show that there's an increase in the flow. There's not even an allegation.
Clients were doing.
Pardon?
Because it's something that your clients.
Because of something our clients were doing. Then there's the discharge into a water course. This is a stream. The established doctrine is that when there is an established stream, you can discharge as long as it doesn't go beyond the natural tolerance of that stream. As the undisputed report says, this is a large stream that could handle multitudes of multiple times as much as water that is actually flowing in there. But when again, all of the claims were barred by the statute of limitations, there's two new claims that are brought up. There's a downspout drain that's 70. They're brought up for the first time on summary judgment. Nothing in the pleadings, nothing in discovery, nothing in the preliminary injunction motion, nothing. Summary judgment in opposition, all of a sudden there's this new pipe that's been installed to the rear of this property. It's downspout pipe, undisputed that it's downspout pipe 70 feet from their property. Okay. And it's not as the engineer states. It trickles out. There's nothing that's going on to their property. There are many parcels of land that are 50 feet wide. This is 70 feet from the end of the spout to their property. Nothing is going over there. Then they also make up something about some pipe, and this brings up actually something happens further upstream that is now increasing it. They bring up another property that my client owns a quarter of a mile away, about discharge on somebody else's property. It's completely irrelevant. And it's again, there's no allegations in either the pleadings, in the motion for summary judgment, that there's been an increase in the flow of water as a result of my client. There's no allegation that any discharge is in excess of what the capacity of this stream. They have a stream. The stream is going to have water that comes through it naturally. More in the spring, less in the summer, less in the fall. And that's just the consequence of this. The lower court got this exactly right. Lower court's decision and order should just be affirmed. Thank you.
Thank you, counsel. Hold on one second. Hold on. You can come up. I'm just waiting for Justice Kane to return. There she is. Okay. Gabrielle Matina versus James Alfieri. Mr. Mikowski is present and Mr. Miller will be on video.
Morning, members of the court.
Just gonna hold on one second.
And so, we're waiting for Joseph Del Conte.
Mr. Miller's not on yet.
Oh,
There we go.
got it. Sorry.
There we go. You see him?
Yes. Can you see him?
Morning. There's Drew. I see him.
All right, you can proceed now.
Thank you, Ron. Again, good morning to members of the court. I'm here this morning to request that the court reverse the determination of Justice Walter granting defendant's motion for summary judgment to dismiss the complaint. In making this request, we maintain that Justice Walter, in his memorandum decision, resolved triable questions of fact concerning whether the transfer of the real property reflected in paragraph 20 of the parties' property settlement agreement was the product of either coercion, duress, or other inequitable conduct.
Counsel, he relied heavily on the fact that it was 4 years between the time that the PSA was signed and there was this allegation with regard to it. And he alleges that that's too late.
Right. The ratification doctrine, I'm familiar with this area, I know what the ratification doctrine is, but that doctrine, as reflected in the case law, really requires that the person have received the benefits of the agreement. In this case, my client did not get her equitable distribution award, and there was a dispute of $19,000, and then there was a dispute on a mischaracterization by the estate of an $8,000 payment, which was actually the repayment to my client of money lent to her late husband, for which she received a W-2.
Okay.
She also was responsible for paying the mortgage for a substantial period of time after the death. As reflected in her answering affidavit, as of the date of that affidavit, she was owed $41,000 in change. So we would respectfully, there's also another problem in the case, and that is victims of abuse and domestic violence do not often immediately come forward because of embarrassment, and they have to make public that. And it was more than an allegation in a complaint. We made a specific allegation or allegations in paragraphs 14 through 16 of the complaint.
So when this agreement was prepared in paragraph 20 specifically, and I believe you were the counsel that represented
Yes, I
her
was.
at that time. Was it brought to your attention at all that I'm transferring this property only because the fact that he threatened to kill me if I didn't do that?
I knew there were problems in the marriage because she wanted a divorce.
Right.
I also was cognizant of the reputation of the defendant. Of the deceased. I did not challenge my client with respect to the question of the divorce, but the answer to that is not that detail. That came later.
I believe looking at the record, it seems as though this was her separate property before. At one time, she was the only one listed on the deed, and she's the only one who was the mortgagor on this matter.
Right. She had frankly it was her property. It was she was making the mortgage payments.
It was a marital residence, right?
Yes, was the marital residence. And frankly, although it was not flushed out, well, it is flushed out. At the time
Was it flushed
of
out?
the divorce, she had the right the absolute right to list that property and sell it. But because she was so afraid of him and what he might do to her, as reflected on the tape that I've submitted to the appellate division, she just stands still. If he was alive, I would speculate she'd still be paying the mortgage. Now, he did reimburse her. He would give her rent checks and such. But the point is that she was really afraid of this guy. There's no question she was afraid of him.
Following the agreement, he was the one that was paying the mortgage and whatnot.
No, he paid it.
Reimbursing her for it.
He was reimbursing her.
Right.
We've characterized that as a rent payment. It was a reimbursement for the mortgage, however the court wants to think about it. But there was no question that she remained entitled and was legally responsible for the payment of that mortgage to Northwest.
He was required under the agreement to refinance within 6 months.
Right, you couldn't do it. It does happen.
Right.
At that point, she could have triggered the clause for the sale, but she was afraid to do that. And the court, I don't want to belabor it, the tape speaks for itself, but she was really afraid of this guy. She really was afraid of this guy and what he might do if he sold that property. That's why she never listed it for sale. And that's why she continued to make mortgage payments subject to reimbursement for the period, what was it, June of 2019 until his premature death in November of 2022. I think this conduct, I think the problem with the case was that we reflected upon it is we pled it, we gave corroborating evidence. It was sufficient to raise a triable question of fact of whether there was coercion or duress or other inequitable conduct under this court's standards in Campbell and in Amoya, where the court dealt with the question within the context of a videotape. And we didn't get the benefit of the favorable inference on that from His Honor. He resolved the question. I reread his decision this morning, and he makes no mention of the tape. He makes no mention of the recording at all in his decision. I'm sure he listened to it.
It was just that it was too late. 4 years is.
Well, he seemed to rely on ratification, but for the reasons I've articulated, she didn't get the full benefits of the agreement. So as I understand the case law, there was no ratification.
What's the only benefit that you're arguing she didn't receive was the situation concerning the marital residence, right?
She did, well, there's a couple of things she didn't receive. She could have sold the property.
Well, she received.
But she didn't get her EDL.
The decedent relinquished all interest in her bank accounts. They divided her personal property. She retained a vehicle as her sole property, maintained full ownership of her own business interests, and free from the marital property claimed by the decedent. And she transferred her interest to the business to the decedent, which she assumed all obligations.
But with respect,
it sounds like there's a benefit there.
Well, there's no benefit to her. There was no economic benefit. She owned those businesses. They were her businesses. He was trying to hang on to them.
Well, he would have a claim for that.
He would have a claim, and he waived on the claim. Just as well, if she's the legal owner of them and the liquor licenses are in her name, and they're separate businesses, they were maintaining the status quo. He kept what he had. She kept what she had. This is really about this real property, respectfully, and whether or not he compelled this transfer by threatening her. And I hate to say it because it's disturbing, but threatening to kill her. And she believed him. She did believe him. That's why she didn't sell the property. That's why she held on to it. So I don't think the fact that she got divorced in June of 2019, and then he died in 2022, where she continued to pay the mortgage and the insurance, the PITI, should really be held against her because they didn't pony up on the question of, okay, let's get the equitable distribution payment to her. That will shut a ratification argument down. They could have, if the family really wanted to take care of this on ratification, write her a check, and they didn't. So I think that's the nuance in this case.
But the judge indicated in his decision then that portion of that's been paid of the 19,000. I think there's 10,000 for.
There was some dispute about. I'm not arguing with you on that. I assure you. There was these lump sum payments that were made, and there was some confusion in her mind at whether that constituted part of the EDL or didn't constitute part of the EBL.
So you're claiming
when we looked at it, she acknowledged in her affidavit.
The difference was of the 10,000 and 19,000 is your contention. That's not accepting benefits.
Right. My contention is she did not get the full benefits of the agreement, which seemed to be
What
what
if she got the full 19,000 at that time? What if they paid the full 19,000 and then would you still be making these claims that,
Well, I think it'd be harder. I think it would be a much harder case to make to this court had he paid up the money. I acknowledge that, but I'm really troubled that this question of ratification within the context of either domestic abuse or abuse and threats can be utilized because women who are threatened often don't do anything about it. They just don't. And ultimately, took a lot of courage for her to say, I'm going to file this lawsuit. It really did. That's why she delayed. She was really reticent about filing this lawsuit. And I recognized that Mr. Miller's a terrific attorney. We were going to face a ratification defense. But I think this is a very, I don't want to use the word unique, but very fact-specific thing. And the case law does seem to suggest, I forget the case, I think it was Dawes, where somebody waited like 4 years and the court determined that, they would allow it to go forward. So I think for the technical reason that she did not get the full benefit, I don't think the ratification doctrine is applicable, but I also think we need to factor in the underlying conduct of the deceased. I know he's not here to defend himself. I understand that. So I don't want to pile on. But the nature of this conduct was such that she was really frozen. She really was frozen. And even when he passed, she didn't do anything for a very long period of time until the claim was made for the property by the deceased parents. So for that,
Just a question on the timetable. I mean, we have the divorce. We have an agreement that the decedent is to have the house put in his name. He's supposed to refinance the mortgage. And if he doesn't, then your client can request within 6 months that the property be sold, and then she'd be paid her share out of the proceeds.
Yeah, she'd get the ADL.
She never did that.
Yeah, she could. She was afraid. She was afraid to put it up for sale.
So then the moment he passes away, you would think, oh, she would be so relieved. And finally, she can now go to the court and say, please get this property sold. Let me get my share. I don't have to now be under this fear anymore. But she didn't.
She moved back.
Months went by, and then the estate did it.
Well, she moved
and
back.
then she opposed it. So
she moved back to the house.
Consistent.
After he died, she returned to the residence. It was her home.
So she had a change of heart in terms of her strategy once the house became available to her.
Well, I don't know if it was her strategy as much as it was her home. And she decided she was going to go back and live in her home. So she did. And then there were some issues that arose, and ultimately, she left. But there was a point in time where she absolutely, after he passed, decided to return to the residence because it was her home and she didn't want to leave it empty.
But prior to that time, her desire was to sell it and get her share, but she didn't pursue that because of the fear that you've now raised.
Well, we never got there from the point of view. He died in November of 2022. And if my memory is correct, it's in the motion paper, so I don't want to misquote the timeline. But I think the family went in with its motion sometime in the February 2023 time period. It wasn't a big passage of time before this thing was teed up for Justice Walter. I think
but in that short period of time, that's when she moved back in and said, I'd like to keep the house.
Yeah. Yeah. So, that's why it is where it is. And, I know there was a lot of motion practice here because it got teed up as a motion. And I'm sure, well, having been there, I know Justice Walter did the very best he could to move it along. And I know it was acrimonious between the parties. Everyone on this bench is experienced, has done divorces. These things happen. But ultimately, the question, I think, for the court is, did Justice Walter resolve triable issues of fact? Did he not give us the favorable inferences that should have flown from the information that was in front of him in the complaint and in the tape? And is the utilization of the ratification doctrine under the facts of this case applicable? We would maintain it's not for the reasons we've articulated this morning and in our brief and reply brief.
When was the time frame then that's after she moved in and she conveyed the property to her management company?
Right.
For no consideration?
Well, no, her father wanted to keep the property in the family and decided that his company would put the bid in, and it did. Justice Walter respectfully, I have no argument with Justice Walter, you know, he's doing his job the best he can. Decided that he didn't like the transaction and he set it aside. You know, it's in the record, it's in his decision, his May 2023 decision. He invited us to bring this action. He reminded us we could bring this action when we were doing motion practice. I'm not saying we, quote, took him up on it, but when I came to the recognition, this is going to have to, we're going to have to file this action, and you're going to have to tell a court that you were the victim of domestic violence and abuse. And if you're prepared to do that, we'll file the action. So we did. And that's where we are.
Thank you, counsel.
Oh, one last thing, and I know it's a side. I'm going to stand on my papers on everything else because this is what this case is about. But putting that aside, I don't want to use the word upset, but the one issue that this was not a frivolous lawsuit. It was not frivolous. I don't think allegations of domestic violence or abuse are ever frivolous. They're always treated very seriously by the courts, in my experience. Thank you, Your Honor.
Thank you. Counsel?
Good morning, Your Honors. Andrew Miller from Webster Zani, appearing on behalf of the respondents. Judge Walters got this exactly right. This was an agreement that was negotiated by Mr. Mikowski, where two sophisticated business folks, the plaintiff and the decedent, had a variety of business interests and marital assets. They negotiated a property settlement agreement that divided up those assets. The plaintiff received a benefit under the agreement, including business interests, vehicles, bank accounts, and things like that. And the only remaining issues were this property and a small payment. And upon the decedent's death, the estate moves forward to try to sell the property, and then and only then does the plaintiff come forward and claim that she now somehow wants the property. And what she first tries to do is, and we got to step back, that this is in the context of invalidating an agreement. So we have a valid property settlement agreement where she has received all of the benefits under the agreement, and then she waits 4 years to try to argue that it should be invalid and that the ratification doctrine doesn't apply. And this, in my view, is a classic case of ratification. Even assuming that she enters into the agreement under duress and coercion, she has clearly ratified the agreement by receiving all of the benefits under the agreement. And to then claim that she was somehow frozen by the prospect of her ex-husband doing something untoward, and that she waited another 18 months to bring this lawsuit, it just doesn't ring true. And the estate has standing to bring this ratification defense. The plaintiff clearly ratified this agreement. And there are only and then on the issue of the payments and the sale of the property, my clients, as evidenced by the record, were working to asking how much is owed for the distribution so that we could calculate that amount. So we couldn't even figure out how to pay the amount because she had not provided the information requested such that we could pay the marital disbursement or distribution. We also were looking for information on how to pay the mortgage off such that we could take the property out of her name. She refused to provide the mortgage information. We had to get an order from the judge directing Northwest Bank to provide us the mortgage information so we could take the property out of her name. And then she refused to provide the quitclaim deed. This is an agreement that, again, Mr. Mikowski drafted. And to come forward 4 years later and claim that it's invalid just rings hollow. And you can sense Judge Walter's exasperation. It's palpable in his decision as to why he issued sanctions. The plaintiff here had engaged in nonstop gamesmanship. The judge issues an order directing the property to be sold such that she will then receive the money she's entitled to under the property settlement agreement. She turns around and immediately sells it to her own company. Then, after being told that that's invalid, she refuses to sign a quitclaim deed. She moves to re-argue those motions, loses, rushes to the Buffalo Housing Court to file a quote eviction proceeding in a property she claimed she was living in, which I'm not going to make myself a witness, but we then walked through the property and it's completely vacant. She's been engaged in nothing but gamesmanship for 4 years. And it's an act of vindictiveness against her deceased husband's parents. Judge Walters got this absolutely right. This is a textbook example of ratification, even assuming there was some domestic violence, which we deny. And to have an instance where you have a deceased party to a property settlement agreement, then the estate is subject to the agreement becoming invalidated because of very late coming claims of domestic violence, would just upset the whole apple cart, so to speak, on how to enforce these agreements. And then I just want to make one quick comment here, which is the one piece of evidence that was submitted in connection with the alleged threats predates the filing of the divorce by a year. So there was a recording of an argument that is 1 year prior to the filing of the divorce proceeding. A far cry from solid evidence of alleged domestic abuse, which my clients flatly deny. So with that, I will rest on my papers unless if the court has any more questions.
I think we're all good. Thank you very much, Mr. Miller.
Thank you.
Thank you, Ron.
Okay, Shea versus Otero, case number 750. Mr. Jacobson is here, and Mr. Kelkenberg is going to be by video.
Morning, Your Honor.
Okay, we can hear you. Can you hear us?
I can now. I apologize for that.
Okay, perfect. Okay, Mr. Jacobson.
Okay, please report. I'm back. This time, I am on the appellant side. I'm representing the appellant in this case, that being Mr. Otero and INW, Iris and William. In this case, this is,
Before we get into the details of it, has the village of Wellsville taken this by eminent domain? I know that you were moving along the process and you had that in the record.
Shockingly, as the respondents have been successful in this, the village has stayed silent. I have an opinion why, but I don't feel comfortable saying that on the record.
So no, they haven't. So we're in the same.
They have not.
Okay.
They have not proceeded with that. And I'm unsure whether they will, depending on the outcome of this appeal. This is a case about an easement agreement. It's undisputed that it was an ingress egress easement that was granted. The lower court ruled that the ingress and egress easement extended across this entire parcel of property, even though they only needed, say, 2 lanes of traffic to do so, which they had always been provided with, and they were provided with by the installation of these storage sheds. Lower court decision has rendered the property entirely unusable because the respondents can only use it for ingress and egress. They can't park there. They can't use it. They can't do it anyways. And now, because of the judge's decision, now the owner can't use it for any purpose whatsoever, even though historically this was for years and years and years a parking lot that was operated by the village.
Right. I have a question about that, because I saw in your brief on page 10 that you wrote that the subject parcel, and this is again just the paved area behind your client's business, was leased to the village of Wellsville as a municipal parking lot for the first year of their ownership.
Correct.
So, and then you'd cited to the record page 223, and 223 is your client's affidavit. And the client says that it was used as a parking lot, but no mention of a lease to the municipality. And I was sort of thinking, well, gee, if it was leased to the municipality, you would think that they would have had to disclose to the municipality, by the way, Village of Wellsville, there's this easement here. So Village of Wellsville, you can't do with what you want, maybe with the lease, because they could have striped it in such a way that they would have denied ingress and egress. And they also would have to notify the easement holders, here's a lease with the Village of Wellsville. So you would have had to do this communication back and forth. And aside from your brief, I don't see it anywhere else on the record that anybody even knew about this lease.
I believe that it was an oral lease and it predates my client. My client purchased the property and it was a parking lot, and then he continued as a parking lot. And then the time came to renegotiate essentially, and the village said, no, we're not going to release it. My client is putting up these storage sheds, and this lawsuit happens together with the village then saying, okay, we're going to take it by eminent domain then. I mean, there are pictures that are in the record showing the entire parking lot. So there's a large area. Half of that is, I believe, owned by the village, but the whole parking lot was not owned by my client. About half of it was. The other half is still used and occupied by the village as a municipal parking lot. My client's half, because they weren't paying rent anymore, had to change his plans for the use, and he did so by installing this storage shed, which the storage sheds were installed in less area than had previously been used for parking. Cars were parked there consistently for years and years and years. He installs the storage sheds with sufficient room for normal traffic to proceed in and out, to gain ingress and egress the whole time. This is the lower court.
I was going to say, I understood that it made ingress and egress more difficult, site-wise, lengthwise, truck access and things of that nature.
Well, looking at the pictures, cars were parked there, and then storage sheds are there in the same exact area. So if there was any problem now, it was the same problem then. And this would have been a great thing to have a hearing on, to say how much, if we're going to be talking about having the reasonable use of this property and only what is needed for ingress and egress, they have to move it 5 feet this way. There was no hearing on this to determine the reasonable use, which is absolutely necessary in this case.
I understand the argument that if there's cars parked there and a tractor trailer arrives at 2 o'clock in the afternoon and there's cars there that are using the cafe and the laundromat, tractor trailer still has a problem in terms of turning around. I get that. I don't know if tractor trailer deliveries come early in the morning or middle of the night, maybe to a plumbing supply store. I don't know. But we have this argument in the brief you had made, and you attached this photograph in the record at 245 about a tractor trailer. And you said, oh, tractor trailers are getting in and out. And it was the same photo that was used on in the motion papers below, as you'd expect. And the other side had made a reply affidavit where they called it a day cab delivery truck in the photo that was in front of the cafe, significantly smaller than the 18-wheelers that previously delivered to the property. So they said they still had that problem. And that's the ingress and egress that they're talking about, is 18-wheelers that can get in and turn around. And for that, they really did need this space. In the brief, you did essentially the same thing that was done below, which is saying, oh no, see, tractor trailers can use it. Do you have any comment now about this day cab delivery truck argument that they had made?
Tractor trailers are tractor trailers, as far as I know. They travel our normal highways every day. This is 2 lanes of traffic. If they can't maneuver in 2 lanes of traffic, be it a U-Haul truck or a tractor trailer, they really use the same amount of space. But this is all exactly what a hearing would be about. If we have to move these sheds 5 feet this way, the point being, we don't need a parcel of property that holds 5 rows of cars in order to get a tractor trailer in. A hearing would be necessary in order to determine the court standard. Again, the court below just applied the general rule regarding easements. You can't interfere with their use of the easement. Problem is that they wholly ignore the long line of cases that say ingress and egress easements are completely different. Okay, ingress and egress easements only apply to what is necessary and convenient for ingress and egress. And the seminal case really here is this Minogue case. The second department In that case, we have an easement that is specifically described. This is 30 feet wide. Court says, well, it's only reasonably necessary to do 12 feet wide. So might say that it's 30 feet. We don't care. It's 12 feet because you only get to, otherwise we wind up exactly what happened in this case. You can't use the property whatsoever. Okay. And there's case after case.
It's an issue whether it's definitively located and whether it's specified in the easement itself as to exactly what the sort of the metes and bounds are within the easement. If it's not, and it's an ingress and egress easement, agree with you completely, that then it's just what's reasonable under the circumstances. Necessary and convenient is the phrase. But here, don't we have it identified by metes and bounds where they talk about specifically every area, every portion that's paved, that's part of the easement. So they have it more identified here. And the judge made particular reference in the decision saying, this is a unique easement insofar as it described the parcel so particularly.
Except it doesn't. Whether you call it the entire quarter acre, the lot that's 105 feet, or you say that it's 30 feet wide. And even then, there is a whole line, which this isn't really an argument that was made, but there are a whole line of cases that say you can move it. Just because they say that it's this 12 feet, you can move that if the court were to move it, can move it to a different location in order to maximize the use of the property, which this is and your argument, Your Honor, would render this property entirely unusable because now we can't use it for anything. All they can use it for is ingress and egress. By the way, tractor trailers, they can't park there. They can only go in and out with these tractor trailers. Well, what they do is they got
to park there to make a delivery. And that was the problem with the plumbing business. They couldn't park their tractor trailer there to deliver toilets and whatever it might have been. They had to go 1.5 miles away to park and pick it up. I mean, obviously that's the placement of these sheds and 2x4s that are frustrating the use of the plaintiff of using this easement by being unable to receive deliveries.
And I understand the argument, and whether they can park is actually a question. There are lots of cases out there say, no, you don't get to park. Ingress and egress means that you go across it. That's it. You can't stop. You can't sit there and hang out. You're in and out. But that's really not the issue here because my client hasn't objected to them parking, making a delivery and immediately leaving.
They can't do that apparently, according to the plaintiff, with respect to his plumbing.
And that's what a hearing would be about.
But isn't this just a preliminary temporary injunction? I mean, so there may be a hearing.
So for the past year, my client has been unable to use the property for any purpose whatsoever, losing substantial sums because of that. And yes, it is a preliminary, but the judge is just going to make the same rule. He's not going necessarily, but it's a strong indication of where his mind is, and it's an error. It's an error as a matter of law, according to a long line of cases, that it's only what is necessary and convenient, reasonably necessary and convenient. If they need another 5 feet, there's a hearing. We do a hearing.
But nobody stayed the ability to have a hearing on the permanent injunction. Your clients could have been pursuing this whole time. They're choosing to argue it now as opposed to pursuing the hearing before the judge below.
The underlying action is still pending. But there should have been a hearing.
Say, gee, we're losing business. Let's have our hearing right away, judge. And then that would moot this, but that hasn't happened.
And then there would be an appeal later, presumably. Because I understand
that your clients win, or unless your clients negotiate something where they say, how about, you can move the tractor trailer here and there, and we'll put a line here, and then use some storage sheds here, and then we all go back and we have a business arrangement. But that hasn't happened either.
That hasn't happened, and the court below should have held a hearing to determine what was necessary and convenient according to the law. That
hearing on the preliminary and then another hearing on the permanent.
Well, that's trial. I mean, the permanent is a trial, but you have to have a hearing. You have to have 2 hearings, really. You have to have a hearing for that, a hearing about how much a bond should be. You should have a hearing, and the injunction statute calls for a hearing when there is this type of question. Is it reasonable and necessary?
In furtherance of Justice Noack's comments and question, you had every right to bring this to action for a hearing, but you sort of sat on your hands and not done that and waiting for this appeal.
That is not true. There are other issues there are actually monetary claims between the parties. So the court is not ready for a final trial below. And thus we're bringing this appeal so that in the interim, until we get to that could be months or years from now, before we get to a trial in this case in the court below. That's why we're appealing from the preliminary injunction as well. And the standard is pretty clear, and the court applied the wrong standard, and I ask that error be remedied.
Thank you, counsel. All right, counsel, it's your turn.
Good morning, Your Honors. Can you hear me okay?
We can hear you just fine.
Very well. May it please the court, first of all, thank you for letting me appear remotely. It is impactful to my clients, and I want to express my gratitude for allowing me to appear in this manner. Your Honors, I had some things I was going to say, as all of us do when we stand up before you and plan to prepare or deliver arguments. But I'm actually going to work back through the discussion you just had with Mr. Jacobson. And I'm going to start with the issue about a hearing. To hear Mr. Jacobson tell you the story of what transpired below, you would have thought that the papers would have screamed all over the place that there was a need for a hearing, that there was a need for live witness testimony, that these issues could not be resolved by Judge Brown without live witness testimony. That didn't happen. It didn't happen because no one from Mr. Larigo's office, and certainly not Mr. Jacobson, raised the prospect or complaint about Judge Brown not holding an evidentiary hearing before ruling on the preliminary injunction motion. Working back to the next item, which is what have we done for the last year and 2 or 3 months? Mr. Larigo's office has not pursued any type of hearing, has not endeavored to lift a finger to move Judge Brown in any way, shape, or form towards final resolution of this matter or towards lifting the preliminary injunction, which of course he can do because, as this court well knows, the judge issued that finding and that determination within his discretion. At the tail end of his comments, Mr. Jacobson argued that the wrong standard has been applied. And I think that's actually ironic because, of course, in Appellate's brief to this court, they argue throughout the entirely wrong standard, which is that Judge Brown erred in issuing the preliminary injunction, when in fact, the matter for reversal would require this court to find that he abused his discretion, which he did not do. Because, of course, there is ample evidence in the record to support his determination, not just with respect to the well-known preliminary injunction factors, likelihood of success, established both through the contract and RPAPL 15, but the irreparable injury, which, Your Honors, I believe, Judge Nowak, you had referenced some comment about the use of the space and the inability to receive deliveries. That was absolutely part of the court's consideration. And there was testimony, albeit by affidavit, indicating that, in fact, the mechanism that the appellants here had used to really be spiteful and install their storage sheds in a way that eliminated the ability to use the space was wrong. And it was...
Well, all right. Well, yeah, I mean, you talk about it being spiteful. I mean, I don't know if we can glean that from the record. What we do see from the record is that, your clients had obtained the property that, well, I guess there's 2 parcels. It was, I think, a 2010 and a 2012 or 2013 purchase. So there were 2 separate purchases. I thought that the cafe and the laundromat, the building where those 2 tenants are, that came later, I think, and maybe that's important, because that deed was the one that referenced this easement. And I realized that if you're going to buy a piece of property and there's an easement for just a little bit of a ingress egress drive through, but there's no parking for your tenants' businesses, you might say, well, it's not worth so much. But if boy, that building comes with what we could use as a parking lot, fantastic. Now it's terrific. The problem is, of course, the easement doesn't say parking. The easement says ingress and egress, as Mr. Jacobson pointed out. So I'm wondering whether your client tried to have it both ways. They tried to say, well, let's do this. Let's define the metes and bounds of the easement so large that we, for all practical purposes, can have a parking lot for our tenants. But by the same token, we're not really getting an easement for parking. And that may have I don't know if that now with Judge Brown's order kind of bit them, because Judge Brown said specifically, you can't use it for parking, but you do have an easement over the whole area, so you got to take down the storage sheds. And it seems like that's where we are. Did I get that wrong in terms of the negotiation, the purchase of the property and how the easement's worded?
I don't know if you got it wrong in terms of how the properties came together. I don't recall, Judge Nowak, if the 2010 purchase or the 2013 purchase of the 82 North Main. So at one point, you were correct about that. They were two parcels, but they're both 82 North Main. I don't have an explanation for that, Your Honor. However, in 2013, the second half of that parcel, if you will, was acquired. As far as the easement is concerned, I do think Your Honor is mistaken in the sense that it references parking. It references a parking lot. It references the entire paved area of the space that is behind. And this sort of dovetails into the conversation that you were having with Mr. Jacobson just moments ago, which is, he and his clients want to shoehorn this into a situation where we're dealing with an easement that addresses a specific number of feet. And whether that's 12 feet here or 12 feet there, as long as you have the ability to come in and out, that is really what the easement speaks to. And here, the granting language in the 2006 easement agreement that was granted to the then owner of 82 North Main, and I'm sure the court appreciates this, no one in this case was the writer of that easement agreement. So it's really hard to tell what the intent of the parties was other than gleaning it from the easement itself. And in true contractual parlance, that's exactly what the court is tasked with doing. And I don't believe there's any ambiguity in it. It says 3 different times that it covers the entire paved portion of the premises behind what is essentially a conjoined 82-86 North Main Street. I think the issue where Your Honor may be a touch mistaken is just given the use of the property over that period of time. There's certainly evidence in the record that at the time my clients acquired it, and for decades prior to that, it had been utilized as a parking lot, essentially to service those buildings that affront the Main Street drag, if you will, in Wellsville. And so I don't think there was any sort of conniving or anything along those lines in terms of trying to join those two properties. It was, really it was a matter of, this is advantageous to us. We have a plumbing business here. We also have the ability to operate, through rental, this Chelsea's Cafe and some of the other tenancies that they do. And certainly the use of the easement during that period of time. And frankly, Your Honor, I will just say this, during that entire period of time, it was as a parking lot up until the respondents acquired their property at 86 North Main, which to our thinking actually lines up really well with the Albright v. Davey decision from the Third Department in 2009 that's cited in our brief, which really talks about what is the intent of the parties here. This is an easement. It's no different than a contract, and the analysis that pertains is incumbent upon us all as lawyers or judges to assess what it was the parties were getting at. And I think it's significant for this court's consideration that it does reference a parking lot, that at the time it was given over, it was used as a parking lot, and that in fact, eliminating any doubt about whether this easement could be moved, it says it's the entire space, the entire paved area. It doesn't say it once. It doesn't even say it twice. It says it 3 separate times. And the significance of that is that to address Mr. Jacobson's point just a moment ago, it doesn't say 2-lane road. It doesn't say ingress and egress, and we're going to fight about 5 feet here or there. It says we're entitled to use the entirety of it, because let's not forget, the easement also grants more rights than just the rights it granted to my clients. It very specifically, and in more than one instance, articulates rights on behalf of the public, on behalf of my clients' customers. So, the idea that this was just this mechanism that was ginned up in order to allow the folks who own 82 North Main to operate their businesses and come in and out, skirting by particular obstructions that were placed over the easement area, it's sort of a farce, Your Honor. It's not accurate to what transpired. And the last piece of it I would say is, even if there was good faith, and I'll withdraw the spite, Your Honor. I didn't mean to inject emotion into it, but even if it was